Yani bu
한번 남북가 많이 떠올 투일에서 파워 이뻐
낭미래요.
Thank you.
Kindly unmute yourself, please.
barusan. Kayo lagi. 어디다? 싫어. 치우잖아.
Mana lại?
Nó sẽ gây ổn ở trong núi này. Này này này. Đúng rồi. Ura. Em đi.
Maningda phammasira.
Good morning, respected honorable judges, distinguished guests, members of the bar, learned advocates, officers of the High Court, ladies and gentlemen. It is my privilege and honor to welcome you all to the High Court of Manipur Distinguished Lecture Series 2026, held today at the Auditorium of the High Court of Manipur. Today's lecture series is dedicated to 4 contemporary and significant themes, that is, jail jurisprudence, alternative dispute resolution, artificial intelligence in the judiciary, and professional ethics in the digital age. We are deeply honored by the gracious presence of our chief guest today, Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. We are equally privileged to have with us the functional president, Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, along with our honorable judges of the High Court, esteemed members of the bar and bench, and other distinguished dignitaries. May I now respectfully invite our esteemed dignitaries to kindly take their seat on the dais. May I request Registrar General and his team to kindly escort the dignitaries to the dais. We shall now move to the felicitation ceremony. It is our privilege to honor the distinguished dignitaries present among us, whose wisdom and service continue to guide and inspire us. May I request Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, to kindly felicitate Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. May I now request Shri Ojes Mutum, Registrar General, to kindly felicitate Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur. May I request Shri K.H. Ajit Singh, Registrar Judicial, to kindly felicitate Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. May I request Sri K. Nirojit, Registrar Translation Wing, to kindly felicitate Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. May I request Srimati Monalisa Maibam, Registrar Vigilance, to kindly felicitate Honorable Mrs. Justice Golmai Gaipushilu, former Judge and Director of Manipur Judicial Academy. May I request Ms. Puspa Gurumayum, Secretary of High Court Bar Association of Manipur, to kindly felicitate Sri Lenin Hijam, Advocate General of Manipur. May I request Srimati Haubam Bisheshwari Devi, Managing Committee Member of High Court Bar Association of Manipur, to kindly felicitate Sri S. Brajabihari Singh, Chairman of Bar Council of Manipur. May I request Ms. Gitarani Waikom, Joint Secretary, High Court Bar Association of Manipur, to kindly felicitate Sri N. Kumarjit Singh, President of High Court Bar Association of Manipur. May I request Ms. Silori Laisom, Joint Secretary of High Court Bar Association of Manipur, to kindly felicitate Sri S. Bimol Chandra Singh, President of All Manipur Bar Association. May I request Ms. N. Jyotsna, Member of High Court Bar Association of Manipur, to kindly felicitate Sri K.H. Samarjit Singh, Deputy Solicitor General of India, High Court of Manipur. We would also like to felicitate our dignitaries on the extended dais. May I request Sri Ojesh Mutum, Registrar General, to kindly felicitate Madam Vijayalakshmi Brara, better half of Honorable Justice N. Kotiswar Singh, Judge, Supreme Court of India. May I request Srimati Monalisa Maibam, Registrar Vigilance, to kindly felicitate Madam R.K. Banita Devi, better half of Honorable Justice A. Bimol Singh, Judge, High Court of Manipur. May I request Srimati Janet Khongbrai Latpam, OSD, to kindly felicitate Madam Hidangmayum Ramita Devi, better half of Honorable Justice A. Guneshwar Sharma, Judge, High Court of Manipur. Thank you. May I now respectfully invite the honorable dignitaries to the dais to light the ceremonial justice lamp, symbolizing the light of knowledge, wisdom, and justice. Requesting the dignitaries to light the ceremonial justice lamp. I now have the honor of inviting Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, to deliver the welcome address.
Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India, and Ma'am Dr. Vijay Lakshmi Brara, Honorable Mr. Justice A. Bimol Singh, Ma'am R.K. Banita Devi, Honorable Justice A. Guneshwar Sharma, and Ma'am H. Ramita Devi, Sister Judge, Honorable Mrs. Justice Golmay Gaifulchilu, former Judge, High Court of Manipur, and now Director, Manipur Judicial Academy, Shri Lenin Hejim, Learned Advocate General for State of Manipur, Mr. S. Chittaranjan Singh, Learned Additional Advocate General for State of Manipur, Shri S. Brajbihari Singh, Chairman Bar Council of Manipur, Shri N. Kumarjit Singh, President, High Court Bar Association, Ms. Pushpa, Ms. Vaikarani, Ms. Gitarani Vaikom, Ms. Silori, and Ms. Jyotsna, office bearers. Shri Bimol Chandra Singh, President, All Manipur Bar Association, Shri Samarjit Singh, Deputy Solicitor General of India for High Court of Manipur, Shri Ojish Mutum, Learned Registrar General, High Court of Manipur, Shri R.K. Umakanta Singh, Learned Senior Government Advocate and Public Prosecutor for State of Manipur, Learned Senior Members and Learned Members of the Bar. I know all of you by name by now. Pardon me for not mentioning each one of you by name. Considering the exigency of time, I am not doing that. Learned judicial officers, again, I know each one of you by name. Pardon me for not mentioning each one of you by name. Learned members of the prosecution branches, both High Court and District Courts, nominated legal aid defense counsel from across the state, nominated police officials from Manipur Police Department, officials of the Manipur Judicial Academy, members of the High Court Registry, my dear young students, students of law from across law colleges in the state and from the Manipur University Department of Law, and I would add my fellow students of law. Most importantly, members of the Fourth Estate, both print and electronic media who are covering this event, distinguished guests, ladies and gentlemen, and all those who have joined us through the video conferencing platform. A very good morning. With immense institutional pride and standing with all humility today at this podium, I warmly welcome all of you to the inaugural edition of the High Court of Manipur Distinguished Lecture Series 2026. This lecture series is an initiative conceived as a permanent platform for exchange of legal knowledge, constitutional thoughts, professional experience, and contemporary judicial discourse. At the outset, I deem it appropriate to say that today's gathering is significant at least for three reasons. One, it is undoubtedly an academic event. Two, it is equally an institutional event. Three, above all, it is a moment of collective pride for the people of Manipur and for the legal fraternity in particular, that an illustrious son of the soil who is adorning the bench in the highest court of the country is the chief guest today. Welcome, sir. On this opening note, we are deeply honored to welcome Honorable Mr. Justice N. Kotiswar Singh. It is, in a sense, homecoming, but nonetheless holds a very powerful manifestation. I say so again for three reasons. Three distinct reasons, if I may say so. One, for the legal fraternity of the state, his journey from these very hills and valleys to the highest court of the land is a powerful narrative of perseverance, scholarship, integrity, and public service. Secondly, for our young lawyers and law students, particularly those in the gallery there, it is living proof that geographical distance is never a barrier to constitutional destiny, if I may use that expression. For our judicial officers, it is a reminder that excellence, when pursued with discipline and conviction, knows no institutional boundaries. And thirdly, for the people of this state, it is a matter of enduring pride that one of their own has ascended to the apex judicial institution of the nation. The distinguished lecture series has been conceived with a larger vision. Courts are not merely institutions of adjudication. They are repositories of constitutional values. Their strength lies not only in judgments delivered, but also in ideas exchange, more particularly in platforms like this, which are intellectual exercises and academic pursuits. The law, after all, develops not in isolation, but through continuous dialogue amongst judges, lawyers, academics, students, and society at large. It is this dialogue which forms the nucleus of every vibrant legal system which is embodied in the Constitution itself. The framers of our Constitution debated, reasoned, sometimes disagreed, then persuaded themselves, and ultimately arrived at a collective constitutional compact. The constitutional narrative of India is therefore not one of rigid certainties, but of evolving principles shaped through recent discourse. Ergo, any institution committed to constitutional governance must also remain committed to intellectual engagement. The distinguished lecture series seeks to serve precisely that purpose. The themes chosen for today's lecture cannot be more relevant. Topic is made up of 4 themes, which, though distinct, are invariably interconnected. They are dovetailed with each other and inextricably intertwined, if I may say so. They comprehensively remind us that law is not static. The interregnum between established doctrines and emerging realities often presents difficult questions and complicated questions also. It is during such periods that institutions must muster the courage to adapt without compromising on foundational principles. The bench and the bar are therefore called upon not merely to apply legal rules, but to engage with the broader constitutional implications of contemporary developments. That responsibility becomes particularly significant in the times we live in. The Constitution of India does not envisage courts as isolated citadels. It is a living document. Rather, it contemplates institutions responsive to societal needs while remaining steadfast in constitutional fidelity. As we deliberate today on liberty, dispute resolution, technology, and ethics, the four themes which constitute the today's topics, we are in fact examining different facets of a common constitutional endeavor, ensuring access to justice, preserving public trust, and strengthening the rule of law. On behalf of the High Court of Manipur, with all humility at my command, I extend a most cordial welcome to all our distinguished guests and participants who are present here physically in this auditorium, and all those who have joined on the video conferencing platform. We eagerly look forward to the illuminating lecture that is to follow. I do not want to stand between you and the lecture. Thakachari, thank you.
Thank you, my lord. It is now my proud privilege to invite our chief guest, Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India, to deliver the special address.
시스템 떨어지지 않는다. ꯉꯁꯤꯒꯤ ꯁꯚꯥꯁꯤꯗ ꯂꯦꯡꯁꯤꯟꯕꯤꯔꯤꯕ ꯃꯌꯥꯝꯕꯨ ꯑꯩꯅ ꯍꯟꯅ ꯈꯨꯔꯨꯝꯖꯔꯤ. Honorable Mr. Justice Sundar, Chief Justice of the High Court of Manipur, Honorable Mr. Justice A. Bimol Singh, Judge of the High Court of Manipur, Honorable Mr. Justice Guneshwar Sharma, Judge, High Court of Manipur, Honorable Mrs. Justice Golmai, Agaisiful Silu, former judge and director of the Manipur Judicial Academy, Sri Lenin Singh Hijam, Advocate General, Manipur, Sri Brajavihari Singh, Chairman, Bar Council of India, who just left, who are amongst us now, and Sri N. Kumarjit Singh, President of the High Court, Bar Association of Manipur, Sri Bimol Chandra Singh, President All Manipur Bar Association, who also left, I think, the venue. Then K.H. Samarjit Singh, Deputy Solicitor General of India, High Court of Manipur. My better half, Vijay Lakshmi, and R.K. Binita, and H. Ranita also present here. Honorable judges from the District Judiciary assembled here, the senior advocates and the council and other members of the bar, members from the Legal Aid Service Authority Act, Legal Aid councils, defense councils, the police personnel, law students, and members of the media who are present here today. It is indeed an honor and privilege for me to address this august gathering. It is an honor because I have been part of this High Court since inception and always feel privileged to be always in the midst of all of you here. More than a decade in 2013, this High Court was inaugurated. Before that, we were part of the Guwahati High Court. At that time, 3 High Courts were separated: the High Court of Manipur, the High Court of Meghalaya, and the High Court of Tripura. There were obvious benefits, and also, of course, there are certain other disadvantages. The benefit of having a separate High Court is that we are able to concentrate on the growth of the judiciary here, improvement, and more connectivity with the people for whom the judiciary is meant for. But at the same time, we also miss the exchange of ideas. In a common High Court, I remember many of my colleagues, contemporaries were here, sir, present here. We used to go often, not only to Guwahati, but also other High Courts, other benches of the High Courts of the Guwahati High Court in other states also. So we used to interact with people, exchange ideas. This is, of course, something we'll miss it. But that can be also made up by having this kind of seminars. Do I happen to be from the state? Mr. Sundar, Honorable Chief Justice of the High Court, has already initiated the program of inviting resource persons from other states so that we can learn from their experience, so there can be a more robust exchange of ideas, which is absolutely needed for an optimum and robust growth of the judiciary. Because we do not live in island, in isolation. We can't. The law, which is based on the Constitution of India, has to be followed all over the country, following the similar principles, the ideas which have shaped the Constitution of India, how the various provisions of the Constitution are being implemented in other parts of the country, what are the challenges the judicial system faces while delivering justice. They are all issues, I'm sure, will help us better implementation of the law in our own state if we are able to understand how it is being dealt with in other parts of the country. The Honorable Chief Justice Mr. Sundar himself is one of the finest judges in India. We are very fortunate to have him as a Chief Justice. And after his coming here, he has been working tirelessly for improvement of the infrastructure also. When the Manipur High Court was created, inaugurated in 2013, we also had envisioned that the Judicial Academy should also be simultaneously established. With great difficulty, we had identified the land. I'm told that the same land has been now reaffirmed to be there, because there were some ideas to change the venues, location, but unfortunately it has not really taken shape, which is so needed, as mentioned by the Chief Justice also. The court does not function merely for deciding cases, but also learning, exchanging our ideas on evolution of law, application of law in a peculiar conditions. The kind of laws which are being mostly applied in the state of Manipur, unfortunately, are UAP and other NDPS acts. Very unfortunate. Manipur, which is one of the most ancient states which were in existence before the constitution, which had a very rich history with harmony, with peace, exchange of ideas, of the people residing various places, whether hills or valley, unfortunately has been shattered. I don't want to go into that aspect. We may blame some other outside forces for creating this problem which we are confronting every day, we are facing. But we people living in this state must introspect, whether we are in the valley, whether in the hills. There is a time has come for us to introspect. A society cannot develop merely because of the help from outside. A society has to be strong within. A person who is having a low immunity can be attacked by any kind of illness, even a small fever, not talking of serious illness. A person who is strong from within cannot catch fever or any other illness which afflicts a human being. We need to retrospect what is happening in our society, what has gone wrong with our society. Our state has been literally and practically divided into separate entities without any coordination among ourselves. I don't think a society cannot live like this. Today's society, where technology advancing leaps and bounds, a society which is not stable, which is not at peace with itself, is going to be left behind. Nobody will cry for us. Only a strong, united Manipur can save itself. We must introspect. The blame game must stop. Nobody is going to bother I have been outside the state of Manipur for a long time. After I left in 2018 for Guwahati High Court, then thereafter as Chief Justice of Jammu Kashmir and the Supreme Court of India. And I have been visiting many parts of the country. People ask me what is happening in Manipur. So difficult to explain. People don't know. 99% of the people outside India or Manipur do not know what is happening in Manipur except seeing that people are killing each other. And we can't live in a state of blame game only. Nobody will have time for us. We have to keep our house in order. The main responsibility is with ourselves. There has to be systemic failure everywhere in the state. Institutional failure. Manipur used to be proud, a great land of education. People from neighboring states used to come here. The colleges, DM college, the schools also, government schools. I myself never studied in a private school when I was in Manipur. We had wonderful government school, high schools. What has happened to that? What has happened to the college? What has happened to the university? The youngsters are going away from the state for better education. In spite of having a very rich tradition of education in Manipur, something seriously gone wrong with our state. A time has come for us to introspect, rebuild ourselves, why we have gone wrong, try to ascertain. We must stop blaming others. That is what I felt when I was been going around across the country. They asked me what is wrong with Manipur. And of course, being in a profession, I cannot openly express my views, but quietly listen to the kind of shock, sadness when people tell me about everyday killing. It is not stopped. In the 80s and 90s, the valley was afflicted with serious issues of insurgency. Institutions were not functioning. We thought we have improved. In the 20s, there was semblance of peace, stability. Unfortunately, that has been shattered. I can tell you very frankly, nobody will have time for Manipur. Because their concern will be not only for Manipur. We cannot blame the administration all the time. We cannot blame the center for all the time. They have to look after this vast country. Only a Manipur which is strong from within will gain the respect and a kind of attention the state would deserve. If we are not able to stand on our legs, show our resilience, show our capability, which all us are capable of. The corruption has steeped in the society, destroyed the vitality of the society. We must think of it. The future generation will not forgive us if we are able to stem the tide. In the field of sports, Manipur used to make headlines. It is still making headlines. But we don't have the infrastructure to develop the talents. This is something which is bothering me, and I thought before I touch on the topics, today's topic, I must say a few words about what is happening, what people think of Manipur outside.
This meeting is being recorded and summarized.
It's a huge challenge before us, Manipur society today. We have to rebuild our society from being fractured, divided. We have to identify those greedy, selfish people who are destroying our society, our nation. Manipur High Court was to be a thriving High Court. Unfortunately, today what is happening? Because of these problems, judges are confined in their respective areas. The Meiteis can't go to the hills. The tribals can't come down to the valley. The lawyers practicing in valley cannot go to the hills. The lawyers practicing in the hills can't come to the valley. Is this the one we had envisioned when we established the High Court? When we established the High Court, the idea was to reach out to each and every citizen of this state, howsoever far away they were living, so that we could reach a nook and corner of the state, underdeveloped villages, both in the valley and the hills, and the students, low students who would pass out, had the potential of becoming good lawyers, would have their career made in this state, in this High Court, district courts which are being established. Today in the hills also we have district courts. Almost all the district courts have been established. It took time. I remember in various districts, the highest courts were the magistrate CGM court, or at best a magistrate courts. But today, in almost all the districts we have district courts. But are we able to make it functional today? This is a very serious issue. We all in the profession, the judges and lawyers, must ponder over, and especially the lawyers, because they have a very important role to play, because as judges we have certain restrictions, issues in publicly airing our ideas. But the lawyers who are free to express their views and exchange their ideas have to play a much more robust role in this. We have to rebuild the society, we have to rebuild our judicial system, which has been fractured. We have to revitalize our law schools, law colleges. Manipur is perhaps one of the few states in the country where we still don't have National Law University. I have been requested, Honorable Chief Justice has been very kind enough to take initiative and has been in touch with the administration. But till date, we have not seen, we have not been able to realize. We need quality education in law also, not only in other disciplines. And foundation of a National Law University, I'm sure, will greatly give a fillip to our legal education, improve the quality of law education in the state, which will ultimately, the law students here, they are going to be the future judges and lawyers of the state. Therefore, it's very important that we also have a robust legal education. I'm sure and I hope that we will soon have a national law university here also, like any other states. I must first thank the Honorable Chief Justice, the judges of the High Court for inviting me for this, for giving a speech. And some topics were suggested to me, all the four, and very important actually, the bail, ADR, artificial intelligence in court, professional ethics in digital age. And I thought that I'll speak a few words on each of these topics. Touch the salient and important aspects of these. Each of these topics obviously deserve a very detailed examination. But I'm sure Honorable Chief Justice will carry forward this by inviting other resource persons on some other occasions. And I'm very happy that he has been taking interest also. Last time it was in month of March also. Very learned advocate, very learned in the field of criminal law, had come here. He had done a very extensive, he also shared his views, how the audience participants had interacted with him, shown a lot of enthusiasm and interest in the subject which he was discussing. And I'll be requesting the Honorable Chief Justice also to have this kind of function as frequently as possible. We need to have this exchange of ideas, especially from outside resource person. I am not saying that Manipur has a dearth of resource person experts here. There are a lot of very learned senior advocates also here. They are also doing their contributing in their own way. But then getting more from outside also will infuse freshness into the ideas and subjects we are dealing with. As I come back to my topic of discussion today, on bail jurisdiction, I just want to, especially there are students of law also, so I don't want to be very highly technical. Just that in India, that was in 1977, we got independence in 1947. So it took about 30 years to emphasize this fact that bail should be the rule and jail be the exception. In the famous words of Krishna Iyer, in the case of state of Rajasthan versus Balchand, where he stated the basic rule may perhaps be tersely put as bail, not jail, except where there are circumstances suggestive of fleeing from justice, thwarting the course of justice, repeating offences or intimidating witnesses. This principle continues to be relevant till today. The basic fundamental principles of bail remains the same. Only that conceptual or theoretical basis or the principle on which why bail is given importance is looked from various constitutional provisions also. Bail is not merely a procedural right enshrined in the CRPC, but it is derived from other constitutional values. For example, in Motiram versus State of MP 1978, said if a bail bond is to be given, suppose a person is a rickshaw puller. If he has to give a bail bond or surety of 1 lakh rupees. From where he will manage it? Therefore, it should be non-discriminatory, non-arbitrary, which is a concept which is traceable to Article 14 of the Constitution, equality before law. All the students would know the basic concept of Article 14 is not merely equality of law, but also lack of arbitrariness, non-discrimination. So, therefore, the whole concept of furnishing bond also is traceable to that concept of Article 14. And another article which is also play a very important role in the jurisprudence of bail is Article 21. Husainara Khatun versus State of Bihar in 1979. The students of law would understand the concept of law, the case of Husainara Khatun. What has happened is that in the state of Bihar, there are many under trials who are languishing in jail for years together. Some of them were for 5-6 years. On what charge? The charge of theft. Today we can't imagine a person who is charged of theft will be in languishing jail for 5-6 years. Because even if he is convicted, he would be at most convicted for a few months or maybe a maximum year or so. But there, so many under trials were languishing in jail for years together. The matter was taken up by the Supreme Court. A very famous case, you all students must be knowing. The Supreme Court was shocked. What is happening? People languishing in jail for years together for petty offences. Then they said, no, release them all on bail immediately. All those who have served more than actually if they have been convicted, they were released on bail, acquitted. Now, the whole concept of Article 21 is speedy trial. Because if a person is detained for a long period, languishes in jail, then he has a right to be released on bail. So this concept, 1979, Husainara Khatun, I have just given some examples. Now, however, things change. There has been conscious effort from the Supreme Court also, High Court also, how to regulate. Because there has been uniform application of law of bail. Not only by the courts also, but how people are being arrested by the police. I will not take much. I will just first, of course, Satinder Kumar Until, which is the latest in this regard, it essentially reiterated the law laid down in Arnesh Kumar versus State of Bihar in 2014. In Satinder Kumar Until, the Supreme Court has dealt with the bail jurisprudence in a much more systematic manner. If you go through Satinder Kumar Until's case, what has been highlighted is that they are broadly classified into 4 categories. Though it is not classified as such in the CRPC or BNSS, but for the convenience, 4 kind of categories, as we have seen in Satinder Kumar Until's case. There, the category A, cases where a person can be charged of offences, punishment of which can extend up to 7 years. Another category is those where persons can be charged of offence committing, who can be punished for by life imprisonment or such serious cases, more than 7 years, etc. Then persons who are charged under various special acts like NDPS, UAP, PMLA, others, special laws. So how, especially coming to what has happened is that what we have seen is that there are lot of under trials who are booked for committing offences for less than 7 years and they are languishing in jail. There, the Supreme Court explained that for offences punishable up to 7 years, arrest is not an automatic consequence of an FIR. The Supreme Court highlighted that the officer must be first convinced that the accused has committed an offence. That is not merely sufficient. In addition to that, the officer must be also satisfied that such arrest is necessary. Necessary for what? To prevent from tampering of evidence, to prevent the influencing of witnesses, or to secure his presence in the court. But in any event, the officer must record his reason for arresting. It is very important, section 41. And section 41A says, where the arrest is not necessary, notice of appearance under section 41 may be given, is to be given by the police, so that it helps in the investigation. Therefore, in section 41, it puts a responsibility on the police officials. If a person is charged an offence who is punishable less than 7 years, ideally you should not arrest. If you want to be arrested, you must be satisfied on 2 counts. Number 1, that yes, he has committed this offence, and number 2, that his arrest is necessary for these reasons which I mentioned. Only then you arrest. Now, what is the responsibility of the court also? When a person is arrested for committing offences under this category, the court must be also satisfied that the police officer has given reasons for his satisfaction on these 2 counts. The court must not mechanically approve any arrest which has been made by the police, because the consequence can be serious, as mentioned in Ernest Kumar and in the case of Ernest Kumar, because if the police acts contrary to this mandate, departmental action can be taken. Similarly, if the judge does not apply his mind in ensuring that provisions of section 41 has not been followed properly while approving arrest by the police, then he may be liable also for contempt of the High Court. So these are very important areas which Ernest Kumar had laid down. Unfortunately, this had not been practiced in spite of direction of the Supreme Court. That was reiterated by this court in Satyendra Kumar until. So I would request the law students also, particularly, if you want to understand bail jurisprudence properly, please go through these 2 judgments. One, Ernest Kumar versus State of Bihar of 2014, and secondly, the Satyendra Kumar until of the Supreme Court, which was decided in 2022. They are very important aspects of law. Yes, I just want to mention about a few sections of the new act under BNSS. More or less, it remains the same. However, some fundamental changes have been made. Under section 479 BNSS, bail can be granted to the first time offenders who had not been convicted earlier if they had spent 1/3 of the sentence for which the offence has it has been prescribed under the Act. If a person is, the maximum punishment is 7 years or say 6 years, if he has spent 2 years, he would be entitled to be released on bail, provided he is the first time offender. And this benefit will not be given if they are facing multiple investigations or charges. So this is one important change which have been brought by 479 BNSS. There is also very important responsibility given to the jail superintendent. The jail superintendent himself has to verify as to how many under trials are there, who are the first time offenders who have spent, then they can write to the court for the release of that. So without the intervention of the person himself under trial and the lawyers, because of this role to be played by the jail superintendent, a person can be released. So this is to ease the functioning in the court. So it's a very important development which is provided under subclause 2 of section 479 of BNSS. As far as anticipatory bail is concerned, not much changes have been made, except that in case of a sexual offense committed again to a minor of less than 16 years, anticipatory bail cannot be granted. Similarly, in case of accused persons who have been charged of committing gang rape of a girl who is less than 18 years, again the anticipatory bail cannot be granted. These are some changes. And also another change which have been brought in is that initially under the old CRPC, a judicial magistrate can grant police custody for maximum 15 days, but that is at one time. Judicial magistrate will grant either for 7 days or 10 days or 15 days as the case may be. But under the new Act, under the new BNSS, these 15 days can be split in parts. That enables the police to arrest a person for 3 days first, then release him. Then again after that, after a gap of 4 or 5 days or maybe a month, maybe a few days, week, he can be arrested again for 1 day. This is basically to enable the investigators to get the maximum advantage, utility of the detention of the accused. Because what has happened is that a person, the IO may be seeking some report from the forensic, which may take time, a few days. So till he gets the report, the accused remains in custody of the police. Instead of that, they will say, okay, it's going to take time, then release him. So these are very important changes which have been made under the new Act. That is, 15 days can be split into various parts, not necessarily at one go. But ultimately, there is, this is what I mentioned, the fold belt, also similar, more or less same remains. Skin size, big pura. It's on the. Yeah, that's okay. Ubo Pongrusibo Noy, Mataktagi. You can't read, na? Okay, so sorry, I should have been much bigger font. 479 BSS, I have just explained to you whatever which showing now. Anis Kumar Satinder, I just explained to you also the difference, how. Please read these two judgments, it will be very important for you. The Honest Kumar is very important. Checklist, section 41, the checklist. What is the two reasons, two satisfaction. First satisfaction is that the police must believe that he has committed a crime. That is not sufficient for arresting. Another satisfaction, he must also record that if he is released on bail, he may tamper with the evidence, he may influence the witness, he may run away. These satisfaction must be recorded. Failing which, departmental action can be taken against the policeman. Similarly, against the magistrate also, for not verifying that before the arrest was made, the police had really arrived at this satisfaction. These are very important because there are many cases, petty offences. The jail is filled with many petty under trials, where the arrest is not actually needed. Otherwise for serious cases, these of course did not apply to very serious cases like rape, murder. That the principle remain the same. But this is for the offences, punishment of which is up to 7 years. So that unnecessary arrests can be made. These are very important safeguards provided under the law. Matangi slide. Now this of course I have explained NDPS, as you read, there are special provisions, NDPS, PMLA, UAP, POCSO, ACXT Act. What is the peculiarities of these special acts? Normally, the criminal principle is that, in criminal law, the principle is that every accused person shall be deemed to be innocent till proven guilty. The burden is always on the prosecution to prove the guilt of the accused. But if a person is charged under these, there is a presumption of guilt. In NDPS, if a person is caught with 1 kg of ganja or heroin, the presumption is that he is guilty of committing this offence under NDPS. So he has to prove that no, I was merely, it has been planted on me. Though it may have been recovered from me, I did not know that it was recovered from my car. So all this, explanation he can give, but nevertheless, it will be first presumed that he is guilty. Similarly, PMLA, UAP, POCSO, SCS. Therefore, the bail, the consideration will be much more stricter. It will have therefore, special acts also provide. First of all, the bail cannot be granted unless, for example, in NDPS, the prosecution is heard, must be given 15 days of notice. Then the prima facie, the court will feel in NDPS that the court has to be satisfied that he is not guilty of this offence. Number one. And number two, that there is unlikelihood of him committing any offence. Only when these two conditions are fulfilled, a person will be granted bail under the NDPS Act. Similar also in PMLA. And UAP also very strict. If the court feels that the person is, the allegation against him is prima facie true. Prima facie true means on the basis of the documents being produced by the prosecution. If the court feels that it is prima facie true, then he can't be released. The court also will examine other 3 conditions also in case of UAP Act. What is called tripod test. That number one, he is not a flight risk, he will not run away, he will not tamper with evidence, and he will not influence witness. Only then he can be granted bail. Then POCSO also, there is if a person is charged of offence, in the trial also there is a presumption of guilt. Therefore, that in bail, getting bail also in the POCSO matters, the court will be much more stricter. But at the same time, it is also important, as held by the Honorable Supreme Court in the most famous case is Najib case. Najib case, why it says that all the strict provisions of law cannot stand in the face of violation of Article 21. If a person is subjected to prolonged detention, then all these strict provisions of law will melt away. If the trial is not concluded in time, if the investigation goes on for a long period, 5-6 years, then all the stringent provisions will not come into way. That's very famous Najib. So these are certain things perhaps it can be kept in mind in the case of. And then I'll come to the next chapter in ADR. Alternative dispute resolution. Also very important. We are all used to this adversarial system in the court. What is the meaning of adversarial system? We file a petition or plaint claiming certain rights, then it is objected by the other side, the defendant or the respondent, they file their objection or written statement. Then the court frames the issues, what is to be decided, what is the bone of contention between, what is the essential issue, what is the dispute between the two parties. The issues are framed, then the parties lead their evidence, then the court decides. That's the adversarial system. But then what is the alternative dispute resolution? So this is a concept which is gaining ground, of which I will be talking about. Now I just give this important figure. An hour in a court, in a Supreme Court, the amount of money which is being used, consumed or spent by the system, not by the lawyers, I am not talking in terms of the lawyers' fees. 47 lakhs, about 47 lakhs per hour. How do I calculate? In a Supreme Court, typically there are 2 judges sitting, and 2 judges are being paid their salary, about 2-3 lakhs, whatever it is. So it comes to minimum 4 lakhs. Then there are 2 bench clerks there. Then 2 court masters, the 4. There are 4, 5, 6 other staff who are assisting the court functioning. You add the driver of the judge, who also has to be paid his salary. You add the salary of the zamadar, usher, and apart from this, you add the salary of all other staff in the registry. It's a rough picture. I asked my law clerk to make a tentative figure. It is not be correct, but based on various parameters. So it costs about 47 lakh in the Supreme Court of India. 1 hour, it consumed 47 lakhs of the country's resources. In a similar manner, in Manipur High Court, there is small High Court, therefore I have compared to Manipur. In some of the big High Court, it will be much more. Allahabad High Court will be about 100 judges, so it may be about 50 lakhs also, I don't know. I have not tried that. Manipur High Court will be about 5 lakhs per hour, 5.66. Just sitting or hearing the cases, you can imagine that this bill has already, the meter has already ticked. Similarly, in a district court also, 3.43 lakhs. And in a family court, for example, 0.45 lakhs. So every sitting hour of sitting, it costs the public. And many cases are resolved, but sometimes it is not resolved also. If it is resolved, very good. If the case is resolved, even if we spend this money, worth it. If it is not resolved, every hour this money of the government will tick. The precious public resources will tick. The next, that is how we just try to find out, to work out the cost in a Manipur, in a High Court, for example, single judge sitting. So this is the rough estimate. Next. Now, what are the alternative, apart from this court-based dispute resolution, what we call adversarial system? What are the other methods? The arbitration is one method, mediation is another method, and through lok adalat also, then through negotiation. Now, coming to arbitration, which is one of the methods of alternative dispute resolution, it is, in the beginning, it was some kind of, not really an alternative, because the nature of the process was very akin to the adversarial system. In 1940, which ruled the roost till 1996, Arbitration Act of 1940, even though it provided for an arbitration clause and a decision by the arbitrator making awards, but at every stage of the process, it was liable to be challenged before the court. Appointment of arbitrator, or for example, or some process in the arbitration, it was not allowed by the arbitrator, that will be challenged before the court. So, off and on, even in the arbitration process, it used to come to fall back on court of law. So, intervention was there. So, that was not working properly. The government of India made some attempts in 1976. They made some attempt to bring in this process of ADR. 1976, for example, amendment was made in Order 32A. At a time, Family Courts Act was not there. Family Courts Act came in 1984. So when matters pertaining to family matters disputes, which was being decided by the district court at that time, the 1976 amendment enabled resolution through conciliation. Similarly, in a suit against the government, the court also enabled resolution through conciliation. So there are some elements of ADR was incorporated in the system in 1976. But the real change came in 1996, when Arbitration Conciliation Act, which is based on UNCITRAL model, was adopted. Now, the autonomy of the arbitrator, the intervention of the court became much less, making it really an alternative dispute resolution mechanism, effective resolution mechanism. At the same time, the government also thought that as far as the existing cases which are pending before the civil courts are concerned, there must be also provision for resolution through ADR mechanism. Therefore, Section 89 was amended in 2002, 89 of the CPC. It was brought in, which enabled the court to refer to various form of alternative dispute resolution mechanism. That was of course challenged by in the Salem Advocate Bar Association, which was struck down. Salem brother is there from Tamil Nadu. It's a very famous case, Salem Bar. It was a foundational case in helping the growth of the law arbitration and mediation and alternative dispute resolution in India. The Supreme Court upheld this provision providing for ADR mechanism in as per Section 89. So that was very important provision which all the law students must know. I will not go in detail except to say that the court, wherever it felt that this matter can be resolved through ADR mechanism, would refer for mediation or conciliation or arbitration. So that would help resolution of cases in a much faster manner. And of course, I mentioned Balco also. Balco is another important case where it stated that in matters of arbitration, referring to this Arbitration Conciliation Act 1996, it says that, because as you know, this Arbitration Act consists of two parts, Part 1, Part 2. Part 1 basically deals with domestic arbitration, Part 2 with international. But court used to interfere under Part 1 also in respect of foreign awards, if it is executed, sought to be executed in India. The Balco said, no, don't disturb. So these are some important, I will not go much in detail, there are some important amendments made to Arbitration Conciliation Act of 1996 in 2015, 2018, 2023. One of the most important facets of Article 2015 amendment was that a statutory time limit was given, that arbitration should be completed within 12 months. So this is very important. There are many other important facets also, which I am not talking. Then 2018 also another, the important section 12A, pre-suit mediation. For example, in Commercial Courts Act of 2018, it made under section 12A, it made pre-suit mediation a condition for filing. Before you file in a commercial court, you must exhaust this means of mediation conciliation. Try to resolve it through this ADR mechanism, then you file a case. Now Supreme Court has made it very clear in very recent case of Patil Automation versus Rakhesa Engineers, that if you don't exhaust this pre-trial mechanism, your suit will be dismissed, liable to be dismissed. To encourage mediation. So very important. And of course, the most important is 2023 Mediation Act, because mediation, the process of mediation was spread in various statutes. For example, we know in Lok Adalat is being held, so it is there, part of their process is there. In the Lok Adalat we hold it. In family court also it is there. Then in the section 89 also. Then in the family courts. Then commercial courts. Now 2023 Mediation Act now is a very composite act now. It provides how mediation can be held, and that any resolution arrived by mediation can be equated with a decree. So it can be executed as if it is a decree. So this Mediation Act 2023 has totally synchronized, systematized the various provisions of mediation found in other statutes also. Mediators, how the mediators are to be appointed, mediation council also have to be, now unfortunately that is yet to be constituted. Now the whole branch of mediation is going to come up. Now it is very important for law students also especially. You must study this because it will give you an opportunity to be a good mediator, because the whole, apart from being a lawyer who will be skilled in the art of advocacy, in the adversarial system, there will be another branch of lawyers who are trained to be mediators. And mediation has, scope is not only confined to the court-related matters. There are concept of community mediation also. where again the Legal Service Authorities Act also will become relevant. If there is a fight between two communities or two localities, Mediation Act can be also invoked, where, see, these are all big opportunities coming up in the sphere of this alternative dispute resolution. So, how party reaches adhesion today? So, these are just at a glance you can see. As far as ADR is concerned, you get in Section 89. An Arbitration Conciliation Act 1996 is there for specifically for arbitration. Mediation Act already come into existence 2023. Commercial Courts Act 2015, I mentioned Section 12A. It is compulsory to first take recourse to this process. Then Legal Service Authorities Act also. I think you must have been also exposed to have some experience of Lok Adalat. Whatever, say, award is made under Lok Adalat, that also is equivalent to a decree of the court that can be challenged before any other court, except on the ground of fraud or something like that, fraud or impersonification. That only the High Court will have the power. No other court will have. Because there is a matter also pending before the Supreme Court. How do you challenge the award made in a Lok Adalat? It gives a finality so that there is no lingering of the legal process, the advantage of these awards made under these ADR mechanism. Because otherwise in normal courts, a decree given by a district judge or decree given by a sub-judge can be challenged before the higher adjudicatory forums, before the district court, before the High Court, before the Supreme Court. But an award made under these, once the award is made, then it becomes final. Consumer Protection Act also provides for mediation. MSMED Act. MSMED Act means Micro, Small, Medium Enterprises Development Act. Is also very important, especially for Manipur. We know Manipur is not an industrial state, but we have small handicrafts, small industries, small scale industries. If suppose the very interesting aspect of MSMED Act 2006. Now, if there is a dispute between supplier and the buyer, there is a provision mandatory arbitration under a facilitation council. They will first try a conciliation, and if there is a failure, then it will first try for arbitration. And the interest payable also earmarked also under the MSMED Act, so that the financial condition of the small scale industries are protected. Where this ADR also a part of that process. So these are important statutory provisions where we find ADR mechanism at play. How the movement of ADR has been pushed, both by the court and both by the state. As far as the court is concerned, I mentioned also Salem Bar, it upheld as mechanism, upheld court-referred settlement, and AFCONs also very important. AFCONs also laid down what are suitable for mediation. AFCON's case stated that those disputes relating to trade, commerce, contractual obligations are suitable. Similarly, consumer disputes, then tortious liability cases, then family disputes. These are suitable cases for ADR mechanism. But at the same time, AFCONs also mentioned that there are some cases which are not suitable for ADR mechanism. For example, cases PIL, for example, or cases filed in a representative capacity. Because you represent a litigant, a plaintiff represents a particular group of persons. So the person, maybe that he may not be authorized to, as far as the settlement is concerned. He may be authorized to move the court, get a proper decree, order from the court, but he may not be authorized because he is representing so many people. So in a case of typical representative capacity, that this is, AFCONs has said is not advisable, not suitable. Election petition, because it's governed under the separate statute, these are not advisable. Not. Then criminal offences also, they are also not suitable. And cases involving fraud, fabrication of documents also not suitable. And cases involving minors and mentally challenged persons. So these are areas where AFCONs has said that yes, in these cases, the ADR mechanism is not really suitable. But as far as the state is concerned, how the state government is trying to give a boost to this movement is because of the National Litigation Policy 2010. In today, unfortunately, most of the 90% of the cases, especially in Manipur, are against the government of Manipur. Mostly government of Manipur. So if we are able to resolve the dispute through conciliation, mediation, obviously there will be a big leap forward and a reduction in pendency of cases. And of course, the enaction of 2023 Mediation Act has been the government of India has realized that the importance of mediation. Therefore, these are some important steps taken by the state to improve, strengthen the ADR mechanism method of resolution of disputes in the country. Of course, there are some issues about this. There still be challenges faced in this movement. First challenge is from the lawyers, actually, in mediation. Because lawyers, we are trained to succeed in the court by defeating the opponent. So we feel that, yes, we have done well when we are successful in the court by defeating the other side. The mindset in mediation, what has happened is that you come to some kind of compromise because you can't win both. Where one person win means he has to take everything and the loser loses everything. But in mediation, both come together and negotiate and give and take relationship. There, the lawyers who are trained in the adversarial system are not really suited. Therefore, there is a special training program for the mediation. I am told, brother, also I think there must be mediation training for the lawyers also. I think this should be extended even to mediation. This training should be also exposed to the law students also. The difference in nuances, how we approach in dealing with adversarial system and the ADR mechanism. How do we approach? These are very important. Well, these are some challenges which I would not take much time in this because the time also now already 12. I will just come to the next topic of artificial intelligence in the judiciary. This is very, very important for us today. Today is a time where artificial intelligence has penetrated each and every aspect of our life. Is not merely judiciary, all other aspects, how AI is being used there are very important aspects about this AI. The Supreme Court of India in November 2025 published a white paper on artificial intelligence and judiciary. It is a research document to examine the applicability and the challenges. So it's kind of survey, kind of study made by the Supreme Court of India by examining the AI tools which were already being used in the judiciary and in different courts of the land and also abroad, and challenges. And thereafter, the Supreme Court has published its regulations for use of artificial intelligence in courts 2026 in 3rd June 2026, just a few days before. Now it has crystallized in a much more definitive manner how AI is sought to be used in Indian judiciary. In fact, it is at a draft stage, and the comments have been solicited from all stakeholders and still open till 20th of June 2026. The important features of this regulation published by the Supreme Court is that AI must be used strictly as an assistive method and be subservient to the judiciary. It must assist the judicial making process, and it must be subservient to the judicial authority. These are basic principles of the final authority. Has to be ultimately the judges. Finding of fact, finding of law on the law, and ultimate decision making will be with the judicial officers. Now the framework is applicable not only in the Supreme Court, but it will be applicable to the high courts, and all the courts in the country, in all the tribunals, and all the statutory commissions. This regulation is going to be far-reaching. Again, I would request all of you to read this regulation, because AI is going to stay in the country, is going to be a very important facet of our judicial making process. So what are the principles to be followed? What are the precautions to be taken? In what manner we can apply AI? What are the controlling authorities, supervisionary authorities, have been all dealt with under the regulation. Therefore, this is going to be this is not an act of parliament, which is devised, but a regulation devised by the Supreme Court of India, which is going to govern the application of AI in our judicial making process. What is happening is that AI has been used by various high courts in their own manner. In fact, Kerala High Court has been a leading example of using AI. Some other high courts also have been doing it, Karnataka, Kerala, and also Gujarat High Court. So what has happened is that there is a tendency of various high courts to develop their own AI mechanism, how to use it. Now, by this regulation, we will have a very standard, uniform application of AI all over the country. Now, this AI, under Regulation 3, it will be used for applying law to the facts, for recording of evidence, framing issues, but with certain limitations. Of course, it will be used extensively for administrative purposes, for filing, registration, cause list, scheduling, notices, defect scrutiny. E-Seva Kendra, we all know, we file our cases, now e-filing is there. So all this will be used, it will be used very extensively. Similarly, it will also use very extensively in the court process, which means what? Legal research, drafting, translation, transcription, and record management. But again, the basic principles to be followed are, which is that the foundational principles, there has to be always human primacy. Human will always remain the prime authority to control the use of AI. And judicial independence. These are two core areas where there cannot be any compromise. Then rule of law must be upheld. The fairness of the system must be also ensured. There must be transparency. There must be accountability, very important, accountability for the use of AI. I as a lawyer can't say that, sorry, I used ChatGPT, I'm sorry, I have cited a wrong decision. No, you cannot blame on the AI. AI is just a tool. You can't blame blame for your mistake to the software you are using. You have to take responsibility, accountability. Similarly, it's equally true for the lawyers, judges. Judges can't say that, oh, so-and-so lawyer has cited this case, therefore I relied on him. The judge has to verify it. But of course, there is a system, we will come to the regulation also. The lawyer has to inform the court that I have used this AI, this software, this artificial intelligence in my drafting, in my pleading, in my argument, in citation of the cases. So the accountability can be fixed. So then there is a provision for continuous oversight, because we don't know, because AI, how it functions is so difficult. There has to be continuous oversight of the use of AI. Then data protection also very important, because we are dealing with very confidential data. In any case, if it is family disputes, you are disclosing so many aspects of your family life which is not supposed to be known to others. Even criminal cases also. Even your commercial cases, claims also. What kind of business you are doing, what kind of, how much your turnover, what kind of issues. They're all documents, information which you don't want to share with the outside world. It should not go out of the system. Therefore, use of AI must, while we are using AI, data protection is a very important aspect. The data integrity also. The data which is stored in our system, we must ensure that it remains true, it is not corrupted, it is not hacked by others. So therefore, data integrity, maintaining data integrity is so important. And equally related issue is about cyber security. So what this now regulation is that, yes, we'll use AI, but in a regulated manner. We'll not prohibit use of AI in the court system, in the judicial system, but we'll use AI, but in a manner which is properly regulated, guided by these various principles. Now this, under Regulation 19, the regulation also has identified what are the permissible use of AI and what are the impermissible use. So in what way the AI can be used in our justice delivery system? It can be used for proper case management, scheduling of cases, transcription I mentioned earlier, translation, legal research, document summarization, litigant assistance, accessibility services, anonymization, document verification, and administrative analysis. However, these can be done only with the prior permission, approval from the nominated officer or the appropriate authority. Because we can't use indiscriminately on our way. It has to be with the proper approval of the competent authority or what is called appropriate authority. Then what are the acts which are not approved or which are not supposed to be used or what are prohibited? Under Regulation 20, see the 21B, no judgment, order or finding of fact or law by algorithmic decision making alone or solely on AI generated material. You can't say this is my problem. You feed in some software and software will give you suggestion, resolution. Judges can't afford to do that. Judges cannot leave it to the AI to solve your problem. You have to read the evidence, you have to apply your mind and come to your own decision, not lift it. So it is absolutely prohibited. You can't say, because sometimes you see chat boxes, you have a problem, this is my problem, they give you the answer. That cannot be done. It's strictly prohibited. No adjudication or sentencing without a human in the loop. Even then output is only advisory. Even sentencing also, you just feed in the computer. He is so-and-so, his character is like this, this is the kind of evidence against him. What kind of sentence? No, that you can't do. The sentencing policy as per our judgments, detail, already principles have been laid down, that we have to rely. Then also, no risk scoring, flight risk, recidivism, bail eligibility or credibility. These are, of course, actually these from our experience. We had in America, that is called American, they apply this compass. Many of you have read about this compass which is used in America, which is found to be very racist in nature, because the data is, ultimately what does AI does? AI, any solution is based on the data which is fed in a computer. Now what is happening in America, most of the cases, all these, those who are charged of offences, petty of the criminal are mostly from the persons who are non-whites. So they will give this solution, the kind of, they indicate those indicators are heavily biased against non-whites. And India is such a heterogeneous state, society. There was a real danger. Therefore, there is a total prohibition of use of AI in matters relating to grant of bail, all these issues. Then AI must be properly explained. Any software which is developed must be fully understandable, transparent. No opaque or unexplained AI where rights or liberty may be affected. It's very important. Then prediction or profiling of the future conduct of parties, accused, witness or counsel. We can't use AI for this purpose also. So these are some of the areas where regulation has laid down that these are areas where AI cannot be used, strictly prohibited. There are important aspects also, because there are a lot of companies, you must have seen, software companies, law firms, they are developing, they are trying to say that this is very good, can use it. You can use it, but not for official purposes. They cannot take part, you cannot use that in the judicial formal judicial decision-making process without the approval of the competent authorities, because they will see, verify how it has been developed, what are the risks involved. Only when it is approved by the competent authority, appropriate authority, then it can be used. Otherwise, no private or third-party provider can take part in our legal system. So these are the areas where the regulation has mentioned about. The competent authority will decide approval depending on the capability, legal compliance, ethics, data security and finances. They're all issues. Anybody coming with that solution, that is a very good solution for you, cannot be utilized, used. Then another area of where the regulation deals is about the sensitive data is protected. We have mentioned also. No transfer of sensitive data to an external system without express written authorization. Prefer AI system that process less personal data. Anonymize wherever technically feasible before training, testing or refinement. Then cyber security audits, at least yearly. These are very important areas where the regulation also has dealt with. And another, because these are mostly new for most of us, except for those young generation, mostly who are in the middle of their ages, AI is still a very, very daunting task to understand. Therefore, the expensive, intensive training is also envisaged under the regulations, which. And for a judge, very important, these are triple C's: curiosity, caution and control. Whenever AI is being used, we must be curious. We must try to understand what is being used in our system. Means awareness, curiosity. Because prevention is the best cure for any kind of. So you understand what is being brought in, used. Because if you don't exercise that part, we may be misled. Same responsibilities towards the lawyers. And caution, do not accept AI summaries, translations, citations without verification. Because it has happened. In Karnataka also, people have cited. In trial courts, pleadings where they had to apologize that this was a mistake. So judges, we have to be very careful when we accept AI-based citations. And advocates also equally responsible. You cannot cite a judgment without proper verification, merely based on AI research, because your submission can mislead the court also. The equal responsibility for the judges and lawyers in the use of AI. The caution is required. Control is the ultimate responsibility. You have to be master of your own system. You have to take responsibility. both for the judge and the lawyers. As I mentioned again, earlier example, you can't say that, sorry, I relied on this system, that's why I thought this is correct view. No, you can't do that. Because you are not relying on another human being who is infallible, but you are relying on a machine who doesn't know. Machine can't think of itself, what is good, what is right, what is bad, what is good, what is ethical, what is not ethical. Machine can't tell you. Therefore, ultimate responsibility is to be taken by the person. Therefore, both the judge and advocate have to be in control and take their responsibility. These are all have been dealt with under these various regulations. Professional ethics in digital age. I'll just come to the last one. The very important thing, AI hallucinations. AI hallucinations are very typical kind of issues which keep coming up, not only in the realm of law, but in other disciplines also. AI hallucination means what? Giving false report or false answer or false suggestions. Why it happens? AI mentioned earlier also, AI depends on data which is in any system, the data which is being fed. Now if you see the internet, Google, WW, worldwide network, worldwide these websites, there are all kind of data which are being fed. Data which are genuine, data which are manufactured, data which are fictitious, fabricated. Yeah. So on the basis of that, what the AI does is to take all this data and gives an answer. Quote, this is the most probable. Therefore, all these mistakes still happen. Therefore, professional ethics now extend beyond courtroom. Now we have to ensure that we, the kind of software use, the kind of AI assistant we are relying on does not suffer from AI hallucinations. Very important. Deep fakes also, they are a big issue. Your photograph is morphed and put in a different context. It's so difficult to verify. So on a naked eye you can't see. You think that photo is genuine. Deep fakes, audio and video. Sometimes, today's a lot of cyber cases coming up. Threat, blackmailing. Do you want to use those data as evidence in your support on your defense? How do you ensure that it is not a deep fake? So these are very important. Then, social media trial. This is another issue. This is part of the new, the world, digital world. Whatever you say today can be misinterpreted and various opinions are given. And you are subjected to intense scrutiny by the public, rightly or wrongly. Now we are living in digital world. So how do we do this? How do we deal with this? Social media trials. Very important aspect. Then client data leaks. Normally, as a lawyer, in the normal situation, the client will come with their physical documents. These are my documents. And lawyer will verify. They will exchange. In a physical form, normally we do. Now, but what has happened? Now in today's digital world, you can ask that, okay, you send it by WhatsApp message. Send by email. But it can be manipulated. It can be hacked. How do you ensure that the data which you have received, you may think that these are genuine data, I have received from my client by WhatsApp message, by email. But you have to ensure the integrity of the data. And also make sure that it is not leaked to others. In a WhatsApp, by mistake, you forward to some other person whom you didn't want to become public. So these are very challenges, ethical challenges we will face in the use of digital data. Then legal influences also. A lot of, experts, they keep talking. If you open YouTube on various aspects of law, there are many scholars, actual real scholars are there. In fact, I learn much in my spare time when I go for a walk or I am on a journey. I just open YouTube. And there are very interesting issues on law, on various aspects of life, You listen to them, but you don't know which one is really genuine or not. Then through this, they try to advertise, because they say some of the best legal, this is another problem. Because as per our this code of conduct, Bar Council of India, you are not supposed to advertise yourself that he is a lawyer based in commerce or criminal. We never show ourselves in advertisement. Lawyer so-and-so is a doctorate in so-and-so, specialized in so-and-so. That is not permissible. But today, what has happened is that there is a tendency of many of these influencers, they say, I am expert in this, as you can contact me. So this is something which we have to be aware of. Algorithmic bias. This is another which I have also mentioned. Bias research tools. There are a lot of research tools you will find. How they work, we don't know. We have to be very careful because they will misguide you. You may be a genuine user. You don't intend to deceive the court, but you want to rely on some software. But that itself may not be a really reliable tool. Now, digital asset gaps. Now, there is another challenge before us. Some of you are very highly talented. Some are still not able to use these digital tools. There is a huge gap also. Therefore, a person who is already well equipped can always have a better performance in the court also. So these are issues. Now, how do you deal with those who don't know how to open their files properly, how to retrieve the file? So these are all ethical issues which we have to deal with when it comes to this professional ethics in digital age. There is nothing new about this ethical, is based on the old law. But the area of the ethical play has increased, especially where we don't have a direct control in a digital world, where we are not fully equipped, that we may be easily misled. But the basic ethical values remain the same. Our responsibility to our clients remain the same, confidentiality. This is also protected by the Indian Evidence Act. What transpires between the lawyer and the client is a protected, privileged communication which cannot be disclosed. We cannot compel anybody. But in today's world, digital world, unknowingly, you may be committing a breach of that because of improper use of the digital media. Unwittingly, you may be breaching the law. So this is an added responsibility in our digital world. And of course, misleading the court is something, an unethical practice which has never been approved. But then, in today's world, as mentioned again, the judges will not have the means, perhaps, to immediately verify that a misleading submissions have been made, because you will be producing some, on a basis of some your research in some AI software, and judge may genuinely believe to be correct, which ultimately is found to be incorrect. But as I mentioned earlier also, the accountability is yours. You cannot say that, yes, it is a wrong software I use, sorry. You have misled the court. Therefore, this also added another layer of responsibility on us in today's world, that when we are dealing with digital world, we have to be much, much more circumspect, careful. Otherwise, we will be breaching our ethical conduct. These are some of the areas, issues I thought I will touch upon. Each and every subject, as I mentioned earlier, also deserves a fuller discourse. I am sure there will be a lot of questions, especially among the young law students in these areas, but it will be difficult to do justice in a discussion like this, spending for about, I think I have spoken more than about an hour or so, but try to touch most of these topics which are of great importance. My request, therefore, again to the Honorable Chief Justice is to have as many frequent discussions. Let there be more question answers. There may be, because these are evolving issues, especially in today's digital world. We don't know how AI is going to shape us. This regulation frame in 2026 is from the experience of last about 5-6 years. The entire contours of the regulation may change after 5 years, because we don't know how the AI is going to shape. In fact, there is already a danger. I remember one of the founders of Anthropic, he himself has warned that we must slow down the evolution, development of AI, because we don't know where it will lead. In fact, AI can be danger to our own survival, humanity. If AI can be a danger to the civilization, it can equally play a danger to our justice delivery system, which is essentially a human exercise. Any other discipline can rely on mechanism, on instruments. Even in surgery also, we have automated surgery. Heart surgeries are being done through robot doctors. We have driverless cars coming up. It can be possible in other fields of our life. But justice delivery system is essentially a human exercise. Not merely correct law, but empathy, sympathy. How do you distinguish between when you, in the same case, there are 3-4 accused, different roles played by them. You can't sentence to all in the same sentence. The role played by person may be more aggravated. How do you sense, how do you deal with this? He may be misled into that, in that case, in that crime. He may be roped in unwittingly. But will the AI be able to justify the difference? No. Ultimately, it will be on the our own understanding of human nature. Because law is nothing. What we do in the court is resolution of dispute of human beings. Disputes, for example, in a case like child custody. Now, it's so difficult to decide. In fact, last few days before I pronounced a judgment also, what has happened is that this child was born in UK, US. The parents could not live together. There was a conflict. The mother allays sexual abuse of the minor child about 1 or 2 years by the father. Difficult to believe also, but nevertheless, allegation was made. Now, how do we deal with this situation? The emotions of the child, emotions of the parents. These are areas where the AI cannot, in my view, properly assess the culpability, the responsibility of the parties. A child is growing up. Custody matters. Today's order may not be valid after 3 years because child's needs, aspiration will be different. Parents, their attitude toward the child may change. Each other may change, may improve also, may deteriorate also. We don't know. We can't predict. So what I'm trying to say, ultimately all this decision-making process, educatory exercise, is essentially human exercise based on our understanding of society, based on understanding of the human beings, on the basis of the factual backgrounds, which may again vary from place to place. There cannot be an equal kind of principle applicable in a family dispute in a city and a family dispute in a village. What therefore I am trying to say is that educating exercise we undertake in the court is essentially a human exercise. We are dealing with live human beings, understanding human psychology, understanding sociology, understanding the social setting, relationship, the community's thought process, how one community thinks of a particular incident is different from another community, which cannot be actually properly undertaken by machines, artificial intelligence. Artificial intelligence, we say artificial intelligence because it is not natural. It is artificial. It is created by human beings based on the tools which we have developed. Therefore, it can never replace our human thought process, human thinking, human emotions. To that extent, understanding of the regulation is so important, how we apply AI in our judicial exercise. Thank you very much for giving this opportunity to share a few thoughts. I am thankful to the Manipur High Court for giving me this opportunity to share my ideas, and I'm sure the Manipur High Court will continue to provide a platform. As I can understand, the legal education in Manipur still has various problems in terms of perhaps providing this kind of interaction with the legal fraternity. In many of the universities, law universities, I understand many judges, lawyers, they go and interact with the students, but I do not know how that is happening in Manipur. Till we develop that a robust mechanism, I would be requesting the Honorable High Court to continue to provide this forum to the law students also. Because law, as I understand, is constantly evolving. What we study in the classroom as law students and what you see actually and what will be experienced a lawyer in the courtroom is totally different. And law students being the future lawyers and judges, the more frequent interaction they have with the actual practitioners of law, it will be much more helpful for the law students. I am very happy that a lot of law students are here today. So I have deliberately avoided using too much of legal jargons and legal expressions and try to make the topics as much as simple as possible for the law students to understand. Because as I understand, all of you are all, what I said is just simple, very preliminary, elementary, you may think though. But then for the law students, how you connect with the evolving legal system is so important. And taking advantage of this, I would like to advise my law students here that the future, your career, don't be very, see, you will be, as you graduate from law, isn't it? You will be finding out where to practice, isn't it? First thing is how to choose, whether to go for litigation, as lawyers, or join the judiciary. Very limited scope you may feel. But don't get, confined to these two aspects of law, as lawyers and judges. There are many other opportunities which are coming up in terms of AI, in terms of mediation. In fact, you can have startup companies on your own. I have seen in Delhi, many young lawyers, once they form a group among themselves, have a startup, chamber on their own. But you need guidance also. If you are not able to get seniors as to guide, to mentor you, don't be depressed. You read all these autobiographies of great lawyers, how they have worked hard, how they have practiced in difficult times, because entering this profession is certainly not easy, but it is full of challenge, at the same time exciting, very exciting, a field giving enormous opportunities. There will be all options open before you, but you have to have a determination. There is no shortcut to this profession. Hard work ultimately will pay. As you enter the profession, don't think so much about the money. People, yes, obviously young lawyers, when they enter the profession, they have to think of their survival. In the process, people tend to compromise with the judicial, our ethical values, code of conduct. Once you breach it, when you enter the new life of this legal profession, it will be damaging to you. Life will not be easy in the beginning, may not be easy for all of you, but you have to overcome it. Your perseverance, your hard work, your consistency, because law is a profession where people will look at your performance, not your face value. Just like when you have a problem, when you go to look for a doctor, first of all you try to ascertain who is a good doctor. You will not just walk into so many doctors, so many clinics are there. You will first try to ascertain who is a good doctor. Similarly, people will try to find out who is a good lawyer. They will not just walk into a lawyer chamber. But how do you do that? Because the goodwill you generate. Goodwill you will generate only by your hard work. And I really worry about Manipur because that's why I began my speech. It was not supposed to be part of my speech. But when I came here, I was so depressed that what has happened to this state? No development has taken place for last so many years. The same roads, the same conditions. Where are we? Big challenge for the lawyers also. But we cannot put the blame on others. We have to work it out, our solution. And the young lawyers, the young students, you must take the right path. You have to think for yourself and ask questions of what is happening in society. Because law students, your study is based on rationalism, on reasons. You will not accept anything which has been told to you. You will verify it. You are trained to question. You are trained to inquire. That inquisitiveness, that must continue. And lawyers, I feel, have a big role to play in our society, guide people correctly. Not to be guided purely by monetary considerations. It is so important. And your good work, your helping hand to a person who is seeking help will always be remembered. And that's how you generate goodwill amongst the society, amongst the people also. And I can assure you, the good works you've done will be always remembered, will be recognized. Sometimes people ask me in Delhi also, in foreign countries, oh, how did you become a Supreme Court judge? It's such a small state, 30 lakhs population. People wonder. I didn't have anybody in the Supreme Court to pull me up. But I kept on continuing my work, whether it's in Manipur, in Guwahati, wherever. Dedicate yourself to the work you are assigned. People will recognize you. There are a lot of good people in this world, in this society, who are willing to recognize. So don't think that just because you are in Manipur, driven by all these problems, violence, keep an optimistic view of life. In each of you, there is a potential to become a great man, a woman. See goodness in others. Try to help others. Compassion for other human beings. Compassion for your neighbors. Being a lawyer, good lawyer is not merely knowing the law. You have to be a good human being also. You have to understand the society. You be critical but not open it. Critical assessment of oneself and others is necessary, but not be too critical openly of others. There are some of the values you have to inculcate. Hard work, dedication, perseverance. These are so important. Exchanging ideas with others, learning new things. It's so important. You don't know when you go to the court, wherever, in a municipal court, in a magistrate court, people look up to you as a lawyer, a responsible person. People look up to a lawyer is a person who is learned. That's why we are called learned. Therefore, what do you say, what do you do? You must exemplify what is best of the lawyers, expected of the lawyers. I was surprised when the chairman of the Bar Council of India, Manan Mishra, said about 30 to 40% of our lawyers, they don't have a degree. Fake. See, what kind of disrepute? Society will have confidence in the judicial system. Our judicial system, we don't have powers like ministers. Or other officials. We are basically adjudicative authorities, and the lawyers will be pleading for the welfare of the others. We don't exercise any, judges, we don't exercise any power in that sense. Our power lies in proper adjudication of the problem faced by the people. Our strength lies in the confidence the people repose on us. If people lose faith in our system, in our adjudicating exercise, then that will be a big blow to the rule of law and democracy. Because without these two, democracy and rule of law, our society cannot progress. The strength of a judicial system lies on the confidence people have on the judicial institution. And judicial institution is not consist only of judges, but also lawyers. Both judges and lawyers play equal role in upholding the values of the society through non-violent means. We must eschew violence. They will lead us nowhere. That we have experienced for the last several decades in Manipur. What violence has brought us? We have seen violence wrecking the state since 80s, 90s. Many have to go out of the state for study outside because of disturbance. Those who cannot afford staying back. If you wish, if you had the financial capability, you would have gone up. But for various reasons, you are not able to go out. But then there is disturbance every day. There is a strike, there is a breakdown, there is burn cold. How do we continue our lives? A society which is driven by violence, division, conflict, how do we make progress? It's a big issue for us. I'm sorry I'm deviating from my topic. But this is something which is afflicting our society. Our neighboring states, Meghalaya is a very small state comparatively. They are doing so well. Assam is marching ahead because they have eschewed violence. We have remained stuck in divisions and violence. In spite of our rich heritage, rich history, our history goes back thousands of years. Where are we? There is something wrong. It's time to understand what is happening within ourselves. There is no point pointing the blame to others. Something that is seriously wrong with our society, our system. As a young student, I would request you not to be misled by people. You must think for yourself. There are many self-proclaimed leaders who are leading us to suicidal situation. This is a state which fought against the mighty powers in the past. With glorious history. In the valley, I am told there are more than 30, 40, I don't know, groups operating. UAP Act has been in operation in Manipur for the last 30, 40 years. What are our institutions? Our education system has almost broken down. There is a mushrooming of private institutions. They are most welcome. But what about the poor who cannot afford these high fees of the private schools? They have to rely on government schools. What has happened to the government schools? What has happened to our healthcare system? How many can afford to go to these many hospitals which have come up, which charge exorbitant fees? How do the poor manage? And we are people of only about, in Valley I think is about 20 lakhs population. 20 lakh population is in Delhi. Shahada district is perhaps more than, they come about 50 lakhs. With 20 lakhs population, we are unable to manage ourselves. What are our officers doing? Local officers doing, local politicians. In places outside Manipur, when you go to Delhi, Bombay, Madras, Bangalore, what kind of impression they have of Manipuris? I don't want to say in detail. There is something wrong in our society. And this can be rectified only by ourselves. Yes, of course, with the help of others. Primarily, responsibility lies with us. Charity begins at home. The reformation we must start at home only. Everywhere, even in notice also, People ask, what has happened to Manipur, Mr. Kotiswar? I said, so difficult to answer. How long we will continue in this manner? Honorable Justice Sundar is Chief Justice, we are lucky to have him here, but he is not going to be here forever. He is doing wonderful things here. But he will go back one day or other. We are the one who is going to remain here. And Manipur is full of potential. We have the talent. We have the potential to rise above all these petty bickerings. We have the strength. We have the intellectual capability. And we have a rich history to guide us, traditions to guide us. Jawaharlal Nehru one day had expressed Manipur as the Switzerland of the East. But we can't go beyond a few kilometers. Jewel, the beautiful hills, the beautiful valley, the colorful people in the hills and a valley used to live together. Mera Hauchongba is one such example. In the time when the Manipur king was coronated, he has to wear a dress of tangkhuls, showing the deep relationship, cultural links between these two. Manipur is a place where all other communities have lived harmoniously. So many communities, very few states in the India, Northeast India, where so many communities are here. For last several years, decades, centuries, living in harmony. But today I can't go beyond Imphal. I want to visit this place, that place. I said, no, sorry, you can't go. I can't go to Churachandpur, I can't go to Ukhrul, I can't go to, not because of I am not wanted or something, but because of the situation. Is this the Manipur which we are striving for? Fractured, divided. I can tell you very frankly, very few understand Manipur outside, except those who are managing the affairs of the state. Others, they don't find interest also. Let them fight. It doesn't matter to us. Violence in Manipur, clash in Manipur doesn't affect others staying in other parts of the country. It doesn't matter to them. That's the reality. So what do we do? Therefore I call upon everybody, the valley, the hills, those who are listening, give up your petty mindsets. Let us live together again in this beautiful place. Living together, living in harmony, as in the past, is only a guarantee to our progress. Any community who thinks that they can progress on their own only is living in a fool's paradise, against the law, against history. We must all assemble together, think over, ponder over, exchange our ideas, what has gone wrong, rectify it so that we can continue to live together again peacefully. Because nobody else will think for us. As I mentioned again, today's world is an age of technology. AI. Nothing is going to matter unless you fall in line with this new development. Only those society which has evolved, progressed enough to be incompatible with the progress made in the rest of the country will be a partner in a progress in the development society. Those who keep on fighting, those who remain aloof from the progress made in the rest of the country and society and the world will be left behind. Manipur there's a danger that we will be left behind. There's a real danger that we will be left behind. Only we ourselves can bring back to earlier life the vibrant Manipur, where people would love to come. For the last several decades, there is hardly any tourists coming to Manipur. Why should any tourist come here? In spite of the beautiful valley, beautiful hills, beautiful lake, nobody wants to take a risk. Any tourist, he goes to a tourist place, would like to relax, enjoy. He doesn't want to get caught up in a conflict, in a sudden curfew. Why should anybody come here? I think I have spoken more than the topic also, beyond my brief as a judge, but I couldn't stop myself. I was in J&K when this violence broke out. I literally cried. I saw many of my friends displaced, uprooted, houses burned down. Was it really necessary? People ask me, what has happened to Manipur? What has happened to Manipur? Some ask me, please tell me the suggestion. I was at a loss. As a judge, I couldn't say much. I couldn't do much also. Today also, I can't do much. Even though I'm a Supreme Court judge, I can't do much because I do not want to breach my protocol, my professional ethics as a judge. But unfortunately, I happen to meet so many people at several occasions, well-meaning people. And I feel so helpless. But the solution has to be found from ourselves, from inside. There are very well-meaning people outside also. But then ultimately it is we ourselves. We have to find a solution. We must start the communication open again. We are not talking to each other. How do we live together when we don't talk to each other? There are some people I know who are interested to continue in this kind of situation. But if the people come out, work together, their designs will be frustrated. Manipur has known to a society where people have lived together in spite of differences in language, in religion, in customs. We must revive that. The history of Manipur shows that we can live. We had lived. Therefore, we can live in future also. Aduna aina mayamda phongdokchari yamna thagatchari mayambu for your kind attention, for bearing with me, for my speech, which both in law and without law also. I hope I am not speaking like a political person, which was not my intention. But I have had very little occasion to interact and share my views. Mapanda ngangmudidi bhap tadamine yam nujunganing de saying na haroda. A lot of people ask me, I try to explain the history of Manipur, but they don't understand because it's very difficult to understand unique history of Manipur, culture of Manipur. Not that easy to understand. And you have to have time also to explain. Unfortunately, what has happened in Manipur, we are not able to explain to the world properly. We are talking among ourselves in the valley, in the state only. We are not able to convey what is the problem we are facing. We are not able to convey what is the proper solution should be. That is why people from outside, except for knowing that there is a conflict in Manipur, they have nothing to suggest also. They can't give good advice because they don't know what is happening in Manipur. So it is our responsibility also to tell the world, because we are living in society with other communities in the world, in the country. Unless we are able to make them understand what is the real problem, they will also cannot suggest what is a good solution. Therefore, their solution will be something which may not, the solution they may suggest may not suit us, because they will be thinking of solution from their perspective, from understanding what they know of Manipur. But very few people know what has actually happened in Manipur. It is very high time we tell the world what actually is happening in Manipur, incorrect, not by distorted, wrongful portrayal of what is happening in Manipur. Only then we will be able to get the proper advice, guidance, support from others who really want Manipur to be a progressive, a stable society. So thank you very much for your kind attention, to all of you, especially to my law student, very inquisitive, very I'm sure you must be looking forward to a very bright future in this system. We must welcome you. Indeed, you have a very bright future, I can tell you, because the lawyers will be needed most in Manipur in trying to resolve so many, not only the personal issues, but also the communal issues which we face. Because you are the one which are guided by rationality, reasons, not by mere emotions. Lawyers by nature are rational, not swayed by emotions. You are grounded on facts, you are grounded on principles, reasons. Thank you very much for it.
Thank you, Lordship. Thank you for the insightful knowledge. May I request Sri Ojesh Mutum, Registrar General, High Court of Manipur, to propose the vote of thanks.
Respected Honorable Mr. Justice and Kotiswar Singh, Judge Supreme Court of India, Honorable Mr. Justice M. Sundar, Chief Justice High Court of Manipur, Honorable Mr. Justice A. Bimol Singh, and Honorable Mr. Justice A. Guneshwar Sharma, Judges High Court of Manipur, and other distinguished dignitaries on and off the dais, distinguished members of the bar and bench, esteemed nominated invitees, law students, participants, and members of the press, both print and electronic media, and all e-attendees across the spectrum who have joined us through the VC platform, ladies and gentlemen. It is indeed an honorific privilege for me to propose the vote of thanks on this memorable occasion. Today has been far more than an academic exercise. It has been an enriching intellectual engagement, a celebration of legal scholarship, and above all, a nostalgic gathering at the home ground. At the very outset, on behalf of the High Court of Manipur and the entire legal fraternity of the state, I express our deepest gratitude to Honorable Justice N. Kotiswar Singh, Judge Supreme Court of India, for graciously accepting our invitation and delivering this distinguished lecture. I most respectfully convey our deep gratitude to Honorable Chief Justice for conceiving and supporting this distinguished lecture series as a permanent institutional platform for exchange of legal ideas and judicial learning. I also place on record our sincere thanks to all judges of the High Court of Manipur for their kind presence, encouragement, and constant support in making this initiative a huge success. Our warm gratitude is equally due to the Director, Manipur Judicial Academy, the Learned Advocate General, the Chairman Bar Council of Manipur, the Presidents and Office Bearers of the Bar Associations of the High Court, and all Manipur Bar Association, Additional Advocate General, Deputy Solicitor General of India, High Court of Manipur, Senior Advocates and members of the Bar, and all other distinguished invitees whose enthusiastic participation has invariably enriched this program and exemplified the enduring partnership between the bar, bench, and the key stakeholders in fostering the spirit of continuous learning. I also acknowledge with great appreciation the presence of a galaxy of key stakeholders across the genre, judicial officers of all ranks, members of district bar associations, law officers, police personnel, Legal Aid Defense Council, and law students whose participation has added immense value to today's deliberations. I must also place on record our sincere appreciation for the members of the Fourth Estate, the media fraternity, who covering this program plays a responsible and informed role of bridging the gap between the institutions and the public. Finally, I would be remiss in my duty not to express my heartfelt gratitude to the officers and staff of the registry, the Invitation Committee, the Protocol Committee, the Venue and Stage Decoration Committee, the Technical Committee, the Catering Committee, the Felicitation Committee, the Media and Documentation Committee, the Coordination Committee, and all those whose quiet but dedicated efforts have ensured the seamless conduct of today's program. As we conclude today's proceedings, we do so with the conviction that the conversations initiated here shall continue to reverberate in our courtrooms, the classrooms, and the institutions. With profound gratitude, I once again thank everyone for their kind presence and participation. Thank you.
Thank you, sir. May I request everyone to kindly rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जनगण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
With this, the formal proceeding of the High Court Distinguished Lecture Series 2026 comes to close. On behalf of the High Court of Manipur, I thank all the distinguished guests and participants for their gracious presence. You're kindly invited to join lunch at Court 1 lobby and the wings. Thank you and have a pleasant day.
Thank you.